Pillay.
Thank you very much, Mr Speaker. It's a pleasure to stand and take a call on this bill. And as I said earlier today, Mr Speaker, it's good to see something that adds value, a bill that adds value before the House, because certainly that hasn't been the case with much of the legislation that we've seen go through over the last week or two, or indeed over since National came into government. But getting back to this bill, Mr Speaker, as I said earlier, and I would like to go through the history of the bill, because it does show a commitment. It shows the commitment of two nations working together for what will only enhance criminal or legal proceedings, civil justice systems in both countries. The Trans-Tasman Working Group on Court Proceedings and Regulatory Enforcement was first established back in 2003 by the Prime Minister Helen Clark and, of course, the Prime Minister of Australia, John Howard. So we see here that it was certainly non-partisan, that it was two nations, two governments working together for the greater good. Now that working group did report back in December 2006 and made many recommendations, which included the use of video technology to allow witnesses to appear while overseas, and also increasing the types of judgments that can be enforced in each country. The agreement between both countries was signed in Christchurch by Leanne Dalziel and Robert McClelland, Australia's Attorney General, and that happened in July 2008. And I think it's quite significant that it happened in Christchurch, which of course is Leanne Dalziel's hometown. And it's because she had put so much time and energy into this work, it was very fitting that she had the opportunity to do that. And I know that for Leanne it was a very important part of her role at that time. And that agreement, and I have to say that I mistakenly, which was pretty ridiculous because I was on the Justice Select Committee, so it was that agreement that was covered by the Law and Order Select Committee, and when they looked at that, they looked at a number of benefits that would flow, and that was by simplifying Trans-Tasman court proceedings, by expanding the range of enforceable judgments, improving the enforcement between both Australia and New Zealand, supporting the success of the Trans-Tasman relationship, and avoiding the incentive, and I think this is really important, Mr Speaker, avoiding the incentive for people to move themselves or their assets to another country to put themselves out of being accountable. So that's really a large part of justice that we've seen by this mutual cooperation, there's no other way to put it, of the Trans-Tasman Proceedings Bill. I want to correct what I said. I mistakenly said a remark that wasn't perhaps very complimentary in terms of the chairing of the committee. I want to acknowledge Chester Burrows, although at times I certainly don't agree with some of Chester Burrows' views, certainly lately when you look at his and his party's views on dealing to employees and taking away human employment rights and indeed human rights in New Zealand. If you look at the 90-day sack at will act that is going to be extended to all employers in New Zealand, those are things that certainly don't bring about a feeling of warmth or working together from this side of the House. And I have to say I was very disappointed in Chester speaking out about that stage. But certainly with this bill, Chester Burrows did chair the Select Committee very well. I know that there were a number of amendments that were recommended by the Select Committee because what's Simon's other name? Simon Bridges. Simon Bridges, affectionately known to everyone as Clark Kent, or Gokwan. As Simon Bridges said, it wasn't the most exciting people are saying Guan is way cooler than Simon Bridges, but that's not the point. I think he's making an honest attempt to look cool and trendy, and I think we should acknowledge that. But as Simon Bridges said, that the Trans-Tasman Proceedings Bill is probably not the most exciting bill that we had before the Select Committee, but it is a hard-working Select Committee. Well, most of the members are pretty hard-working on it. Certainly the Labour members are, but it is an important bill. It's a very, very important bill, and it does enhance the relationship that we have with Australia. I just wanted to perhaps go through just again a couple of the amendments that the Select Committee made, because the Select Committee, there weren't many submissions, but the submissions that came and the feedback that the Select Committee received was very, very productive and very helpful to the Select Committee. And I certainly think that there was a will from everybody on that Select Committee that this bill needed to be brought forward in the best way possible to enhance the relationship between Australia, and to actually see that people are held accountable and cannot use simply moving to Australia, as of course many are doing in droves under this government, even though they said they wouldn't. I think there's, but actually most people do not go to Australia to avoid accountability. They go to Australia because this government has not created any jobs or invested in any training here, or increased wages, despite all the rhetoric, despite all the promises. It hasn't. So whilst the majority of people do go to Australia, especially now because there is no hope of them getting support for their families, probably they go for a quality early childhood education as well now, as we see that being denigrated, and of course many of the other things that are causing concerns around New Zealanders and persuading them to go across the Tasman. But there is a small number who would travel to Australia to actually avoid being accountable for any misdemeanours that they have done in New Zealand. And that, of course, is something that both sides of the House find totally unacceptable, as indeed did Helen Clark and John Howard when they started the working group that led to this bill. And so that's why it is good for everyone to acknowledge the work that was done in the earlier days, not hugely early days, but certainly earlier days, and also the work into now seeing this bill come into effect. As I said, but I do think it is worth acknowledging some of the work that the Select Committee did, and let me also acknowledge the very hard-working staff of the Select Committee who do a fantastic job. We have a really, really good clerk and support people, and also the officials who gave us very good advice, and that was very much appreciated not only by the Chair but by all members of the committee. And when you are able to give send back to the House a very comprehensive report that certainly improves the bill, that can only happen when you have the support of good Select Committee staff and, of course, advisors working as a team alongside the members of the committee. And in this case, that certainly was the case. So that some of the improvements that the Select Committee recommended were around applications for stay of proceedings, for the power of New Zealand Court to decline jurisdiction, procedural rules of the court, service of initiating documents in Australia, the defendant's address for service, so that as it was introduced, the bill did not expressly allow for a defendant's address for service to be changed to another address in either Australia or New Zealand. Well, I'm pleased to say, Mr. Speaker, that now is able to happen under the bill, because those issues were raised and canvassed and improved during the Select Committee process. There's also issues around the power of an Australian court or tribunal in New Zealand, permitting an Australian court or tribunal to